We often think of laws as these permanent, unchanging things, but that's not really how it works. Laws have a whole life cycle. They're born, they evolve, and believe it or not, they can even die. Today, we're going to trace that entire journey. So that brings us to the big question. Are laws really written in stone? It's easy to think that once a law is on the books, that's it. It's fixed, permanent. But as we're about to see, that's just not the case.
And this quote right here, it just nails it. Law cannot be rigid. Society is dynamic, and law cannot be static. Think about it. Society is always changing, right? Our tech, our values, everything's in motion. So the laws have to keep up. If they don't, they become useless, or worse, totally unfair.
So that's what we're digging into today. We're going to explore this whole dynamic life cycle, how laws change, how they end, and even what happens when they clash with each other. It's kind of like we're writing the biography of a law. All right, let's start at the beginning. Well, right after the beginning. A law is born. And then what? It starts to evolve. And in the legal universe, that evolution has a name: amendments. This is how a law stays relevant and adapts over time without having to be scrapped and started over from scratch. So what exactly is an amendment? Simply put, it's just an official change. It could be a tiny little tweak or a massive overhaul. The whole point is to alter how that law actually works in the real world. How judges interpret it and how it gets applied day to day. Now, not all amendments are the same. They basically fall into two big categories. First, you've got your substantive amendments. These are the big ones. They change the what of the law, your actual rights, your duties. Then there are procedural amendments. These change the how. They don't mess with your rights, but they change the process, the steps you have to take to get things done legally. Let's look at a real-world example of a substantive change. Take the Companies Act. For a long time, it didn't say anything about corporate social responsibility. Then, bam, an amendment comes along and adds a whole new duty for companies to have CSR obligations. That's a huge shift in what's legally required of them. It literally changed the what. Okay, now for the other side of the coin, a procedural change. Think about the Civil Procedure Code. An amendment made mediation a mandatory step before you could even file certain lawsuits. See the difference? Your fundamental right to sue someone didn't disappear, but the process of how you do it changed. A new hurdle was added to the track. It's all about the how. So, laws can evolve. But what about when a law is just done, when it's outdated or no longer needed? Well, they don't just fade away. They have to be officially ended. And that process is called a repeal. It's the end of the line for a law. A repeal is pretty much the legal equivalent of pulling the plug. It's the legislature saying, okay, this law, it's over. It's no longer in effect. It's a full stop. Gone. Kaput. And just like with amendments, there are a few different ways to repeal a law. The easiest is an express repeal. That's where a new law literally says, by the way, that old law from 1982, it's gone. Super clear. Then it gets a little more subtle with an implied repeal. This happens when a new law is passed that's completely incompatible with an old one. They just can't coexist. Finally, there's a partial repeal, which is like a surgical strike. You don't get rid of the whole law, just a specific section that's no longer working. This quote really drives home how final a repeal is. A law is completely obliterated as if it had never been enacted. Whoa, that's intense. But check out that last part. Except as to transactions passed and closed. And that right there raises a massive question. Yeah, what does happen to all the stuff that went down while the old law was still active? What if you signed a contract or got a license or bought a house based on that law? You can't just wipe the slate clean, right? That would be absolute chaos. So the legal system has a built-in safety net to protect what are called vested rights. And this safety net is called a savings clause. It's a super clever tool. When lawmakers repeal a law, they often put one of these clauses into the new legislation. Think of it like a legal bridge from the old to the new. It basically says, hey, even though that old law is gone, any rights you gained or liabilities you incurred under it are saved. They're still valid. Okay, so laws change and laws can end. But what happens when different laws start fighting with each other? It's kind of like a family feud. You've got the big parent law and then a bunch of smaller, more detailed rules that are supposed to follow it. But, well, sometimes the kids rebel. So in this family dispute, there are two main characters. On one side, you have the Parent Act. This is the big law, passed by the main legislative body. But that act is often very broad. So to actually put it into practice, an executive authority creates what's called subordinate legislation. These are the nitty-gritty rules and regulations that flesh out the details. So who wins when they disagree? The rule is simple, and it's non-negotiable. The parent is always in charge. The subordinate rules, the children, cannot go against the main parent act. The parent law is the boss, period. And when one of these subordinate rules gets a little too big for its britches, when it tries to do something the parent act never gave it permission to do, the courts have a fancy legal term for it. They declare the rule ultra vires. It's Latin and it literally means beyond the powers. It's the legal system's way of saying, nope, you overstepped, and the rule gets struck down. Let's make this concrete with a real case. The case of Ram Prasad versus the state of UP is a perfect illustration of this exact kind of legislative family feud. So here's what happened. The Parent Act laid down a very clear rule. For a trial to be valid, you needed a specific minimum number of members present. That's called a quorum. But then some subordinate rules were made that allowed for trials with a different setup, one that didn't meet the quorum requirement. So you had a direct conflict. The court stepped in, looked at the two, and said the subordinate rule contradicts the Parent Act. And boom, it was declared ultra vires, invalid. So let's pull back for a second. We've talked about how laws change, how they die, and how we fix it when they conflict. What's the point of all this? Why does the system have all these seemingly complicated rules? Well, it turns out this whole framework, amendments, repeals, ultra vires, it's not there to be complex for the sake of it. It's all about creating stability and fairness. It's the playbook for how our legal system can handle change without everything falling apart. And that's really why this all matters to you and me. This system is what allows our laws to adapt as society moves forward. But, and this is the crucial part, it does it while protecting some really important things: predictability, fairness, and maybe most importantly, the rights we've already secured. And all of this leaves us with one big thought-provoking question. The whole life cycle of a law is really a massive balancing act, isn't it? How do we make sure our laws keep up with our fast-moving society without sacrificing the stability and predictability that the rule of law depends on? That, right there, is the fundamental challenge that sits at the very core of any legal system.